to commend Ministers McGrath and Smith for bringing it forward before the House. Back in 2014, the House of the Oireachtas decided to enact legislation that would provide a statutory protection to whistleblowers, and there were whistleblowers who came from within the public sector. I think it was a very important piece of legislation that we introduced and enacted in this House. I also think it's important to recall that it was enacted not in response to any European Council directive, but it was decided to introduce it because it was thought necessary from the point of view of issues that we faced in this country. Obviously, the legislation which is before the House this evening and yesterday is slightly different because we are transposing a EC directive as a result of the legislation, but also we're getting an opportunity to make some important changes to the protected disclosure law, which I believe will improve it. At the outset, I just want to say that I think the state should not be afraid to enable individuals within the state or employees in the private sector to come forward to disclose wrongdoing or to disclose a failure to comply with legal obligations. It is the case that when you look at the legislation, wrongdoing is described in very broad terms. It's not just the commission of a criminal offence, as many people think it is, but it also can be the failure or inadequacy of a statutory body to fulfil a statutory and legal obligation. The state should be prepared to acknowledge that that is an important function that is being performed by individuals within the public sector. The legislation that we have here this evening is going to extend it also to private entities, provided that there are more than 50 employees. I think it is to the benefit of the state if it is established, and there are mechanisms in place to establish wrongdoing that exists within either the public sector or the private sector. Similarly, it has to be to the benefit of the state and indeed the private sector if allegations of wrongdoing are made, if they are adequately investigated, and if it is found that such allegations are not substantiated. We all know that it can't be the case that every whistleblower is correct in the allegations that they make. We talk in this House about whistleblowers who we commend and who have done a very honourable job in disclosing wrongdoings, and they've been mentioned in the House this evening. I obviously support and recognise that. But it is also the case that there are allegations that can be made which should be investigated, but they may not establish the allegations that have been made by the whistleblower. I think we also need to look at the fact that the legislation that has been in place since 2014 is extremely complicated and difficult to navigate. I know that myself because as a TD I was the recipient of a protected disclosure along with a retired colleague in this House, which was a perfectly valid protected disclosure that was made under the provisions of Section 17 of the 2014 Act. And I can tell you it was a very demanding process, but we were able to ensure that the whistleblowers and the serious allegation that they were reporting to us was brought to the attention of the state and necessary changes were made. And I must say they were the only two whistleblowers who came directly to me, and I have to say on the record of the Dáil that they were extremely honourable, commendable people, and I think that the public and the public service was improved by the disclosure that they did make. However, it is the case under the 2014 legislation that there's a whole myriad of avenues down which a protected disclosure must go in order for it to be appraised and it to be assessed. That's why I welcome the fact that under this legislation we're going to set up the office of the Commissioner of Protected Disclosures. That will provide, I would have thought, a much more simple method for protected disclosures to be made and for them to be investigated in a thorough and coherent fashion. I also think there's a number of important provisions within the Act or the bill which is going before the House now, which are to the great assistance of whistleblowers. For instance, I know that the Minister has introduced in Section 22 a provision whereby the burden of proof in tort claims which are brought by a whistleblower who claims that they have suffered damage as a result of making the protected disclosure is to be reversed. The reversal of a burden of proof in litigation is a very significant matter. It doesn't frequently happen, but the basis upon which it can happen is if a statute provides for it. And I commend Minister McGrath for the fact that he has introduced this provision in this legislation, and it will give very significant protection to whistleblowers if it is the case that they are subjected to detrimental conduct as a result of having made the protected disclosure. It'll mean that they, when they bring a case against their employer or the person who subjected them to detriment, will be able to say to the court that since I suffered detriment, you must assume that that is because of the protected disclosure that I've made. And after that, it will then be for the employer to put forward evidence to prove that that wasn't the case. So listen, the legislation is worthwhile. I think obviously it is very important that the Office of the Commissioner for Protected Disclosures is well resourced. It's also important that the individuals in the public sector and elsewhere, if they qualify within the private sector, are aware of the role that that office can play. As I said at the outset, I think it's extremely important for the state not to be embarrassed or not to be hesitant about facing up to the fact that there is going to be wrongdoing within the state. Wrongdoing as we see and defined within this legislation. What is important, however, is how we respond to that. And I think the fact that now we're improving legislation to ensure that wrongdoing can be investigated thoroughly shows that the state is not embarrassed or is not trying to hide away from the reality of the fact that there are going to be circumstances where wrongdoing does take place. I think it is also beneficial if we have a very coherent one-stop shop for the investigation of that wrongdoing, that it can be done in a much more expeditious way. And as I said at the outset, it is clearly in the public interest and for the public benefit for there to be established allegations of wrongdoing which turn out to be true. But similarly, it's clearly in the public interest and for the public benefit if we can establish that allegations of wrongdoing turn out to be false. Gur Malgad, Laskin Gurla.